Welcome back to Edwin Eisendrath's It's the Democracy, Stupid on WCPT 820.
Okay, everybody. Yeah, that was interesting. But moving forward, longtime legal journalist Adam Klasfeld is the owner and editor-in-chief of All Rise News. I love All Rise News. I think you should sign up for it. He founded it in part because traditional journalism, as we've talked about a lot so far in this show today, wasn't up to the moment we're in. And that isn't just true about covering politics, it's true about covering the courts, a topic God knows we've discussed on this show. His focus on the judiciary and his reporting is clear, it's thoughtful, it's relevant, and if you read it like I do, it's actionable, which is also enormously important. Adam, welcome.
Much, and Edwin, for that generous introduction. Really happy to be here.
Look, I think you're one of the few national reporters who cover the judiciary who actually spent time recently in Wisconsin covering the Dugan trial. And I wonder if you'll tell everybody, remind everybody what it was, why it was important to cover, and what we can make of the split verdict that we got.
Right. So just to the first point that you made, you're absolutely right. It didn't get a lot of national presence. The kind of familiar faces that I'm used to on the legal beat were not there. The reason I decided that it was very important to cover that case, it's the case of the Milwaukee County Circuit Court judge who was prosecuted for a jury found that she had helped an undocumented immigrant in her courtroom evade arrest. And that happened after a week-long trial. I can go through what emerged from the defense case, but pretty much the nuts and bolts of the case, just from what was never disputed. On April 18th, 6 federal agents showed up to her outside her courtroom, to arrest an undocumented immigrant named Eduardo Flores Ruiz. She went outside in the presence of another judge, and they both had requested a warrant. They said they had an administrative warrant, not a judicial warrant. She refers them to the chief judge of that court. She goes back to the bench, calls up Mr. Flores Ruiz, and escorts the defendant and his attorney through a jury door while there are still 2 federal agents outside. The jury door leads to a restricted hallway, and here's where the case got to have a dispute. Within that restricted hallway, there were 2 exits, a private stairwell where Flores Ruiz could have left undetected, and a public hallway. He exits through the public hallway. The prosecution's case was that she had intended for him to exit through the private stairwell, and that was the clash at the heart of the trial. But at the end of the day, he exits right in front of 2 federal agents. Eventually, rides an elevator with one of them, is arrested outside court when one of the officers identifies themselves. There's a foot chase, but he's apprehended and deported. She is ultimately charged with 2 crimes, helping to conceal an undocumented immigrant, which is a misdemeanor, and obstructing an immigration proceeding. That is a felony. She was convicted of the felony and acquitted of the misdemeanor.
Okay, that's clear, but it's also taken in its entirety confusing, because if you are not right, the thing that she was acquitted of, the misdemeanor, I don't fully understand. So, I mean, say it again, because if she's acquitted of that, I don't know how she did the other thing.
And that's exactly what her attorneys are going to argue in the post-trial motions, at sentencing, on appeal, that they're going to say, essentially, this is a repugnant verdict, not in the traditional sense of the word, although they might think in the traditional sense of the word too, but a repugnant verdict is a verdict that is so self-contradictory that it cannot stand. Now, there's some, Supreme Court precedent that might make that challenging, but their argument is that how can she not have concealed an immigrant, as the jury found, and at the same time obstructed that immigrant's arrest? And it goes into very in-the-weeds technicalities. I can go into the jury notes that the jurors sent that might explain how they reached that outcome. That namely, they had asked, and this was a contested point at trial, did she need to know the identity of the undocumented immigrant who was identified and the subject of the arrest warrant? The response to that question, given by the presiding judge, was yes. In order to convict, she needed to know that the warrant was in the name of Eduardo Flores Ruiz, not guilty. Then jurors had a second jury note, and they asked, does the judge need to know the identity of the subject of the pending immigration proceeding? Different manner of law, they get a different instruction and say, essentially, she needs to have sufficient knowledge of the immigration proceeding, but doesn't affirmatively say needs to know it's Flores Ruiz. Guilty on that count. So the jury definitely went well into the weeds, but from a kind of lay standard, from a standard of anyone observing this trial from the outside, people would be scratching their heads. What gives? You have an acquittal of concealing an immigrant, yet a conviction on a felony conviction of that, on obstructing the same immigrant's arrest.
Well, I respect juries and the work that jurors do. I don't want to second guess yet this, but I find it very odd. But I also find the whole prosecution deeply troubling. And I don't want to guess this. I assume there was some reason that you chose to actually pay attention to this trial more than the facts of this particular trial, but what it means for the independence of the judiciary more broadly.
100%. I mean, there are plenty of trials in New York. I am here in Milwaukee because this case has plenty. It has cast a long shadow on the independence of state judiciaries when federal agents want to go into a state courthouse. As a matter of fact, one of the interesting things at trial, we got a little bit of. I want to interrupt you just for 1 second, Adam, to ask you to speak a little more into the phone. I'm having a little trouble. Sorry, I'm.
There we go.
Yeah, can you hear
Much
me
better.
now? Okay.
Yes.
Terrific. So one of the kind of types of evidence that we heard from trial, we heard about the Milwaukee County Circuit Court's reaction to the fact of federal law enforcement conducting immigration arrests in court. The prosecution tried to argue again and again to the jury that this was perfectly routine, and as a matter of fact, it makes their job so much easier because the person who they're trying to pick up will go through security screening, their set schedules. Well, what it's not convenient for is the people of the state judiciaries, and we heard testimony after testimony about the chilling effect on access to the courthouse for immigrant communities. Eduardo Flores Ruiz was charged with 3 misdemeanors related to domestic violence. And if we kind of pull out the lens and just think of this from a policy angle, do we want victims of domestic violence to be able to access the courthouse to get justice? Or will they be fearful to report crimes, to perhaps be a witness to a crime because ICE might be waiting in the hallway to pick them up? So there were two types of themes, I would say, generally in the trial. It was one, did Judge Dugan do it? Was she trying to help Flores Ruiz evade arrest? That's what she pleaded not guilty to. And her argument was that she was the one who led Flores Ruiz and his attorney through the hallway to a side door that was about 10 feet, 11 inches away from the main door where federal agents were standing. That was the basis by which they were trying to argue for reasonable doubt. Didn't persuade the jury. But that's one set of themes with this trial. But the second set, and you hit on it, and it's the main, the reason this has captured national attention. This policy, this nationwide policy in Trump 2.0 of sending federal agents to courthouses to conduct immigration arrests. What does it mean for the people in those courthouses? One of the witnesses was the chief judge of Milwaukee County Circuit Court, Carl Ashley. And Carl Ashley, and your listeners can Google his statement, and the name is spelled just like it sounds. And he issued a pretty scathing statement about the federal policy of conducting these immigration arrests in courthouses, that it is chilling people from going to use the courthouse to access justice.
Yeah.
He was one of the witnesses for the government in kind of explaining the courthouse policies. But on cross-examination, all of that came out. And we have heard time and again from so many witnesses the challenges that policy has brought.
Yeah, I mean, and when you put these pieces together with others from this year, you see federal agents in and around courtrooms, which could intimidate witnesses, jurors, and judges. You see vigilantes tied to this administration actively threatening judges they don't like, threatening their children. This is an enormously, I mean, I am in awe of the judiciary generally for how it stood up to this really aggressive year of intimidation.
Absolutely. And I will say, I mean, look at this trial. There were nearly 20 government witnesses. Between government and defense, maybe I think 4 judges testified at this trial, a number of attorneys, a court reporter. Imagine the atmosphere in, I don't know if Milwaukee County Circuit Court has a cafeteria, but one can only imagine it's very tense in there right now. And more to the point, any judge who is wondering, remember, I mean, one of the defenses at this trial was that Judge Dugan was, like many people, confused about the state of the law. Did she have the authority to control her courtroom in the manner that she saw fit? What were the limits of her power? The jury found she exceeded it. But as a result of her conviction, as a result of a felony conviction that potentially carries a 5-year sentence, one can only imagine that many judges in that courthouse and any other
around the country
courthouse.
Yeah.
Yes. This is a case with national attention. And the defense theme in opening statements was that this was a policy that sparked anxiety and paranoia and confusion. And one can imagine that atmosphere that has just descended as a result of this verdict is stretching from coast to coast.
What did you feel when you heard the verdict read? Were you shocked?
I got to, as I explained a little earlier, I heard the jury notes, and it was very, I had...
Well, and you heard what they heard. You were there for the testimony.
Absolutely. But the jury notes gave an insight to where they were leaning. And when they answered those two questions, I thought that there was a real possibility of a split verdict. Why were they going so much in the weeds? Why were they diving into the statutory language? And we're very much paying attention to a point that you made earlier, Edwin. This was a jury that I would say did agree or disagree with the verdict. They were working hard. They were listening to the testimony.
Yeah.
I thought that it was a hugely significant thing for the country. I felt that especially based on what I heard throughout the trial, that Milwaukee County Circuit Court will never be the same, and state courthouses around the country won't either. So was I surprised? Was I shocked? I kind of saw it coming through the process of reading the tea leaves of these jury notes, but it's definitely the significance
painful.
Of this,
it's painful.
and the fact that it was the felony count that was the count of conviction.
Really painful.
It's a turning point. It's a real turning point.
All right. Let's move to a different courtroom and some different stories that may turn in a different direction. At least 2 federal judges, and maybe more, but Boasberg in Washington and Zinnes in Maryland, possibly Ellis in Chicago, although she's not there yet, are at least talking about holding the Department of Justice in contempt. That's also unprecedented territory.
Right. I mean, I've been covering the courts for nearly 2 decades, and you always hear about the government's presumption of regularity. It's usually honored, and what is not common in Trump 2.0, this has really changed it because the misleading the court, lying to the court, has become so routine, and the smoke and mirrors have become so routine that judges like Judge Zinnes, who you had mentioned, specifically said that the presumption of regularity has been destroyed. That is a quote that she said.
Yep.
And with Judge Boasberg, very recently, thanks to a ruling from the D.C. Circuit, a 3-judge panel with 2 of the most loyalist of the Trump appointees on that bench, had essentially left unclear about whether Boasberg can investigate a potential violation of his order. That was, of course, I'm sure many of your listeners remember back in March when the planes carrying hundreds of immigrants who were being sent to El Salvador, Judge Boasberg had ordered that the planes be returned, and instead they landed. He has been trying to investigate that since March, and because of 2 very right-leaning judges, Judge Walker and Judge Rao, it remains unclear whether he can take testimony, where he can do the necessary fact-gathering to find out who is defying his order. I don't think so far. I think Judge Zinnes is really going to hammer into that very deliberately. She's been doing this for months, and she had recently ordered Kilmar Abrego Garcia released. I would also keep an eye on what's happening in Nashville, Tennessee, in the Middle District of Tennessee, because very recently, this is kind of breaking news from yesterday, I believe, that in the criminal case of Kilmar Abrego Garcia, his attorneys said that the attorneys for the government going up to Todd Blanche, the Deputy Attorney General, former Trump personal criminal defense attorney, had misled the court. That for a long time they've been saying that the only person the buck stopped was the sitting U.S. attorney for the Middle District of Tennessee, and that he made the decision on the indictment. And they say that's not true, and that they were misleading the court, and at times under oath.
Yeah, I mean, this is as weird and dangerous and unusual territory as the case in Wisconsin, in a different direction. But it all goes to, like, how will the independent judiciary that considers the facts and the law survive a moment where partisanship, at least for one side, is the only measure of truth.
Right. Right. And with Boasberg, you had mentioned the intimidations of the federal judiciary. And then we've seen with Boasberg how the Department of Justice filed a complaint against him in the D.C. Circuit, trying to accuse him of somehow having some sort of ethical violation in his presiding over the case. And, that is not going anywhere because we already saw an en banc panel of that court essentially say that he did nothing wrong by a majority of that court. That said, it goes to show that, if you rule against us, you're going to hear clamoring from Congress saying, we want to impeach you. And on the kind of more shocking end of it, there's also the unprecedented number of threats, and largely against judges across the country who have ruled against Trump, including in federal judge in Chicago.
Yep. Well, which is why I am, again, so proud of the judiciary, as I am of a lot of parts of America that have stood up to an unprecedented and unreasonable attack that we have not done enough to call out. Let me ask you about sort of out of the blue. I've been with Jack Smith back in the news. I've been wondering whether Judge Cannon will actually release the rest of his report, as she was ordered to do, I think, soon, right? Are we going to ever see that?
So she was ordered to rule, and by, I believe, early next, in a kind of extraordinary rebuke, you had the 11th Circuit saying, stop dragging your feet, Judge Cannon. It was a motion, a writ of mandamus was sought by the litigant, saying that she is dragging her feet on resolving the dispute. So at this point, she has been commanded to rule by a certain point. I believe it's by early January. It may be by late December. And so we, as the new year is coming in, listeners, look out for that. I mean, she may rule against disclosure of it, but then it gets to the appellate court, and she has not done well in the appellate court.
She has not.
Remember, you had panels in the 11th Circuit rebuke her twice during her handling of the investigation that preceded the filing of the classified documents case. And had her ruling dismissing the classified documents case actually been had a chance to go to the 11th Circuit, had the election gone differently, who knows if we would have seen another rebuke. But she has a defeated record. I think that's the opposite of undefeated. All defeats whenever a Trump-related case goes to the 11th Circuit. So stand by. It's coming to a head.
That's interesting. Yeah. All right. And then there's, of course, our friends on the Supreme Court. They took birthright citizenship. I don't know why they took it, because there's no controversy. Every other court was pretty clear about this. Right. A fourth grader can read the Constitution and understand that particular sentence. I mean, maybe they took it just to be able to tell the president we're done with it. I mean, I can't imagine the chaos if they actually rule in the other direction. I do think they're likely to, I don't know this, but the tea leaves that the experts tell me, they're likely to rule against the president on tariffs. Do you have any sense about that?
I believe so. Having listened to those arguments, they did not go well for Trump's DOJ. They just did not. And as a matter of fact, even with birthright citizenship, one of the things that I spoke to people about that. I was wondering about that too. They did, as you noted, they didn't have to take the case. And what I keep hearing from folks is that remember, the birthright citizenship case came to them twice. And the first time, Casa v. Trump, they ruled essentially reining in universal injunctions and nationwide injunctions. And when they did that, they essentially forced the government to bring it back on appeal, because one of the major concerns, I think expressed by Sotomayor and others, was that why would the government ever appeal a case involving the taking away of someone's civil rights if they lose in a lower court? Because, if there are no more
injunctions, what do you do about it? Yeah.
Exactly. So because they essentially forced that promise, and I think Judge Barrett wrote about that in a footnote, there was a little doubt that they would take it. And I think most of the folks that I'm speaking to feel that's going to go the same way as tariffs. Now, the Supreme Court has ruled very much in favor of Trump on the emergency docket, but on these two cases, in my conversations with people, I have encountered a lot of confidence.
Yeah, I mean, even when, as I expect they will, and you would know better than I, they rule to finally eliminate the Voting Rights Act, which I think they're close to do.
Yes.
I don't know that will overcome the damage to this administration that getting rid of his major initiative, tariffs, and ending the threat to denaturalize and get rid of 54 million people will do to his administration. So it's interesting.
Absolutely. Those are two of the signature things that he won. And, to rewrite a constitutional amendment by executive fiat, a rebuke saying, no, constitutional amendments. You want to change the Constitution. The Constitution dictates how that's done.
Well, but the Supreme Court has said we can change the Constitution. They've done it a bunch of times, this particular court. So, I do worry about them a little bit. Yeah. Hey, look, your work is great, and people should follow it. Talk a little bit about All Rise News and how people can see it, and why they should.
Thank you so much. Well, I really appreciate it. So All Rise News, you can find it by visiting www.allrisenews.com. I founded it earlier this year in April, just thinking that journalism, and particularly legal journalism, needs to take it up a notch in the Trump 2.0 era. That I had noticed in my history of being a legal journalist, people are waiting for the ruling to come in or waiting for the verdict to come in, but actionable information comes out of these court proceedings all the time, and I wanted to kind of present the legal news in a way that is accessible for people to engage, for people to bring it into people's lives in an era where thousands of protests break out routinely on seemingly a monthly basis. So it is about the law, yes, but it's also about civic engagement. So folks can at www.allrisenews.com. They can become a subscriber, and you can also find me on Substack.
Well, Adam,
at All Rise News.
At All Rise News. Yeah, thank you for that. It was a pleasure talking to you. I hope we do it again.
I hope so, too. It was an absolute pleasure. Great talking.